an expert accountant to determine the community interest. But we don't have the documents or the information in order to determine how much money there is in community stock, as Mr. Mars has not cooperated.
Objection, Your Honor. First and foremost, we cannot proceed. And we cannot proceed. And second, Ms. Roberts was provided all my stock information, including screenshot of filters that I used, starting from the very beginning of stock program. And all the stock options were provided to Ms. Roberts. But again, Judge Flint cannot preside over this matter because of personal conflict of interest with petitioner, me.
Is there any further argument, Mr. Mars, that you wish to make on the issue of whether or not the court should grant the request to equally divide any community interest in the stock?
All community assets and debts should be divided according to equalization payment statement that was shared with the court, and that states that respondent owes to petitioner $34,112.16. Those statements are shared with the court, filed with the court, and are included in evidence. But I state again on record that Judge Flint cannot proceed on presiding over this matter due to personal conflict of interest with petitioner. And this trial is illegal.
I'm going to object. It's non-responsive. It's a waste of the court's time.
And I do need to remind everyone, including myself, that we do have a hardworking interpreter here as well. So we need to pause and make sure we're not speaking too quickly, because our court reporter and interpreter have tough jobs. The court agrees with Ms. Roberts that any community portion of the stock is ordered to be equally divided. If the parties are ordered to meet and confer to see if there can be agreement on the issue of which portion of the stock is community property. If they cannot reach agreement, the parties are ordered to hire an expert to determine the community's interest in the stock. The parties are ordered to, if I may, the parties are ordered to meet and confer on this issue within 7 days of the court's order. And if they cannot reach agreement, they're ordered to hire an expert to determine the community share. And the expert is ordered to be hired within 45 days of the court's order.
Your Honor, can you also order that the parties pay the cost of the expert equally, and that once the amount is determined, that it be paid within 10 days?
Objection.
Do you wish
I
to be
cannot
heard on
afford.
that, Mr. Mars?
Yes, Your Honor. Objection. We cannot proceed with this hearing because of a personal conflict of interest with petitioner in this case. Regarding splitting in half, respondent currently caused about $100,000 of dollars of financial damages. Respondent got all possible costs that she can get from me, and I have no any. Ms. Roberts, please do not interrupt me. This is impolite. Please do not interrupt me. Please do not interrupt me.
Thank you.
Order.
Thank you.
Thank you, Honor.
So,
So,
Mr. Mars, Ms. Roberts, please go on mute. It's just too much feedback.
Your Honor, may I
Mr.
continue?
If I may, anytime either side objects, the other side is going to respect that objection, allow the court to respond to the objection, and it will not be viewed as an interruption. However, the court does find relevant Mr. Mars' position about finances and whether both sides are in a position to equally pay for the expert. So, Mr. Mars, please continue.
Your Honor, I kindly request that only respondent pays for all extra unnecessary costs. And looking at current situation, I do believe that respondent will have to pay punitive damages according to California Civil Code $3,294 for $98,000 and $98,624.47 of total financial damages. And I currently cannot afford any extra payments because you know that I cannot afford even renting home, and damages that respondent did by fraudulent restraining order signed by James Towery back in September 2022 caused irreparable damage that will last with me for about 15 years at best. Also, court was provided all my bank statements per September 15th, 2023, which means current bank statements, and all my latest pay stubs and all my information. And court knows very well that I cannot afford even court reporter in case where I'm going against judge who has personal financial interest in the case, an extremely unethical attorney who was twice requested by court to be disqualified for impermissible pressure on witnesses, emergency screener, professional supervisors, and
It exceeds the scope of the question and is non-responsive.
Assisting. So on the issue of finances, Mr. Mars, is there anything else you'd like to say?
I also would like to say that taking into account damages did by fraudulent restraining order that Ms. Mars did, I will also rather require sanctions by CCP 128.7 for frivolous motion.
Objection, non-responsive.
Sustained. Sustained. And so on the issue of ability to pay, do you have anything else to state, Mr. Mars?
All my bank statements are provided with the court in evidences to my trial brief. Fourth amendment. I cannot afford any payments.
Mr. Mars, please go on mute so I can hear from Ms. Roberts without too much feedback. Thank you. Ms. Roberts, any final comments about who should pay for the expert if an expert is needed?
I believe the court should order it equally paid as it is. The court had ordered that the quadro expert be equally paid, and Mr. Mars is not complying with that order. So ultimately, my client will most likely have to pay up front, but it will reserve the right for her to be reimbursed at a later time. So I do ask the court to have the parties pay equally.